understand there's a motion?
May it please the court, can I begin?
Yes.
Your Honor, again, we would renew our request for you to look at the sufficiency of the evidence that has been provided to this court and to this jury and to make a determination on whether or not it should go to the jury. I think you know the standard and whether or not a rational juror could find Keith Sandy guilty beyond a reasonable doubt of second-degree murder, knowing that there is the justified homicide defense. Now, you have to look at the state's evidence in the light that's most favorable to them. But they still have to be able to prove things beyond a reasonable doubt, and they have to be able to put things in the evidence that a juror could believe gave them enough to find beyond a reasonable doubt. Now, when it comes to justifiable homicide, the second to last sentence of the UJI of 145173 is the burden is on the state to prove beyond a reasonable doubt that the killing was not justifiable. And I just want to repeat that the burden is on the state to prove beyond a reasonable doubt that the killing was not justifiable. Now, when you put that in context and you realize what evidence the state has provided, Your Honor, I believe that it's clear that the state has not met their burden to do so. And I will give you a couple of examples of why I believe that way. First of all, if you recall, the only expert that they have brought to testify that in any way, shape, or form has said that this was not a justifiable shooting by these police officers was their first, one of the first witnesses, second witness, Mr. Noble. Mr. Noble made it very clear that if, and he volunteered this was his quote, if indeed Mr. Boyd took a step or a lunge towards the officers, if he took a step or a lunge towards the officers, then the officer's use of deadly force would have been justified. That is his exact words that he used. If indeed Mr. Boyd took a step or a lunge. As you recall, I was asking that question, and we were I use the word toggle. We were going back and forth with the video, and whether or not he took a step. And I said, do you see the step? And he said, no. And besides the fact that that was the most incredibly non-credible statement, that's it. So, in one sense, their own witness has told this court and this jury, their expert, that if he took a step or a lunge towards the officers, then the officer's use of deadly force would have been justified. Did the state, in viewing the light most favorable, surrender, for example? The officers are taught that they have to make an arrest. They are trained that way, that at some point you have to make an arrest. At some point you're going to close ground to make that arrest. He never surrenders. Their own expert says he never surrenders. So if he doesn't surrender, we know he isn't willingly giving up to the arrest or actually saying, okay, you can arrest me. No, to the contrary, when they are approaching, what does he do? He pulls out his knives. We know that. He poses an immediate deadly threat. In fact, every single fact witness has testified to that. They do not have one fact witness that says otherwise. Mr. Noble himself said, I have no clue what Keith Sandy perceived. There's no testimony about any perception that was reasonable or rationally based that is contrary to Mr. Sandy's that's in evidence. None. Well, there's the part about whether or not he took a step. But that by itself doesn't even matter, according to Mr. Noble, because he'll tell you, I don't know what he perceived, and he never surrendered. So where is the evidence, again, that the government, and it's a heavy burden, yes, but it's rightfully so, that they prove beyond a reasonable doubt that this was not justified, even viewing their evidence in the light most favorable. Then I'd like to point out that we know he never surrenders, and this is the partial transcript of the sworn testimony of Robert Johnson. As you remember, Robert Johnson was a training officer, went through all of that, what they were trained and how they were trained. I asked him the following question. Okay, and this is this transcript that I just got from the court reporter earlier today. Are they trained that when officers are approaching to effectuate an arrest, if the subject pulls knives out of his pocket, that would be an attack? Answer, yes, it would definitely be a threat, and if the officers are close enough, it would be an attack. That's the answer. Where's the rebuttal? Where's any evidence that the state has put into the record that contradicts that evidence? There is none. There is no evidence to say that when Mr. Boyd, based on training and experience, that when Mr. Boyd pulled out those two knives in the close proximity, that was not an attack, as Officer Johnson, former Officer Johnson, testified under oath. That's the way they are trained. Of course, we always ask the question, if you follow your training, how can you be convicted of murder? If you follow the SOP, how can you be convicted of murder? We know you have all the other testimony. Detective Stone saying they didn't violate the use of force. You have Detective Sandy and Officer Perez who never talked to each other, ever talked to each other, perceive and describe the same deadly threat. Two officers, neither one of them ever talking to each other, at the same time, basically, within that split second, shooting Mr. Boyd because of that perception of the same threat. Again, we come back to where is the evidence that supports their burden that they have to prove beyond a reasonable doubt, and a juror has to believe beyond a reasonable doubt that the shooting was not justified. There's argument, and there's argument implied in the questions that were asked. But Mr. Noble doesn't get there for them. He doesn't get there because he actually suggests, forget everything else. Forget the 19 officers on the scene, forget all the bullets, forget all the ammunition, forget all of the irrelevant stuff that the government has argued. Let's focus in on the moment that they shot. Where is the evidence that it was not based on an immediate deadly threat? Mr. Noble said if he took a step, that's how much he's willing to thinly slice it. If he took a step or a lunge. Where did they prove beyond a reasonable doubt that he did not take a step or a lunge? Because that's all they have. They have to prove that under the law, that it was not justifiable. They haven't done it. I think the absolute same analysis goes to the other charge against Mr. Sandy. Your Honor, their burden is a big one, and rightfully so. And I would beg of the court to please take a look at all of the evidence that you've heard, that we've seen, through all the exhibits, and look at all the relevant evidence, if you will, that makes a difference as far as the analysis under the law, under 145173. Look at all of what we have for evidence that supports or does not support the decision that the officers made to use deadly force, and tell me that they've proven beyond a reasonable doubt, or even a rational juror could believe that they proved beyond a reasonable doubt. It's not there, Your Honor. And to the contrary, every single testimony is that he never surrendered, and we know he pulled out knives, and we know he's a deadly threat, and the only thing Mr. Noble says is, I didn't see him take a step. Your Honor, I ask that you direct this out and dismiss this case against Mr. Sandy.
May it please the court, counsel. At this point, Defendant Perez also renews his motion for a directed verdict. I find myself in the same unenviable position I was in last week of following up, and I will once again endeavor not to duplicate the argument. Now, we were just here last week, so I'm certainly not going to go over all the standards that the court knows very well and must consider. Suffice it to say, you must focus on whether substantial evidence exists to support a finding of guilt beyond a reasonable doubt on every element essential to a conviction. Now, this is not going to be a rehash of our prior argument from last week, because with respect to Defendant Perez, he's now in a different position than he was when we first visited this issue last week. Both because of the testimony that's come in through the defendant's cases, but also because of the reasoning that the court has now expressed explicitly on what evidence is and is not relevant to the elements that the state must prove to meet its burden to demonstrate second-degree murder, the sole crime with which Defendant Perez is now charged. And the court has been very careful throughout all these proceedings not to add, either explicitly or implicitly, any element that must be proven with respect to second-degree murder or the defense of justifiable homicide by a police officer. And we certainly saw that last week when you were discussing potential limiting instructions. You're very, very careful not to add any language that could be even considered an additional element. So in looking at this question, we do have to focus strictly on the elements of both the defense and second-degree murder. Now, one of the elements of second-degree murder, as Mr. Bregman alluded to, that the state must prove beyond a reasonable doubt, even according to the jury instruction proposed by the state, is that Officer Perez did not act in defense of another or in an act of justifiable homicide by a police officer. Now, for purposes of this argument, I want to focus on the state's burden to prove that Officer Perez did not engage in an act of justifiable homicide by a police officer, an objective standard, as opposed to looking at the defense of another, which arguably contains a subjective element that requires an assessment of witness credibility. The objective factors do not. Now, as you know, there is some dispute over how one of the elements of justifiable homicide by a police officer should be defined. And we've discussed that both before the case started and throughout the case, specifically with respect to whether a defendant officer's actions should be evaluated from the standpoint of a reasonable officer on the scene with the same training and experience, or whether instead it should be defined from the perspective of a reasonable person in the same circumstances as the defendant. Now, certainly we believe that the case law mandates that Officer Perez's decision be evaluated from the perspective of a reasonable police officer on the scene, incorporating Officer Perez's training and experience, which you've heard so much about, so much testimony about in these past weeks. And of course, the court will ultimately determine the proper standard to be used when we finalize jury instructions in a short time. However, for purposes of this argument, we'll just assume that the court ends up giving the state's requested instruction. Because the fact is, when it comes to evaluating whether the state has presented sufficient evidence to support a finding of guilt against Officer Perez, this distinction doesn't ultimately matter at this time. Because as we know, there are 4 elements to the defense of justifiable homicide by a police officer. Based on the evidence that's been produced and undisputed, the first 3 are not open to dispute. Of course, the first element that must be met is that at the time of the killing, the defendant was a public officer. Of course, Officer Perez was serving in his capacity as a police officer at the time. He's testified to that. There's no dispute. The second element is that the killing was committed while the defendant was performing his duties as a public officer. Again, no question about that. That's the circumstances under which this arose. The third element is that the killing was committed while overcoming the actual resistance of Mr. Boyd to the discharge of a legal duty to arrest him. You've heard undisputed testimony that other officers were trying to place Mr. Boyd under arrest for the felony crime of aggravated assault on a police officer, and that they had the legal duty to make that arrest. Whether or not Mr. Boyd had explicitly been told that he was under arrest is not legally relevant to whether the officers were attempting to place him into custody and whether he was resisting these attempts at the time he was shot. Which leaves us with element number 4. As proposed by the state, this element would read, a reasonable person in the same circumstances would have reasonably believed that James Boyd posed a threat of death or great bodily harm to the defendant or another person. That's it. That is the only element left that must be considered and that the state must disprove. In other words, in order to prevail, the state must offer evidence sufficient to prove beyond a reasonable doubt that a person in Officer Perez's situation, with his same training and experience, could not have reasonably believed that Mr. Boyd posed a threat or great bodily harm to Officer Weimerskirch or others. This element requires a laser focus only on the reasonableness of the belief regarding the degree of threat posed by Mr. Boyd at the time the decision to use force was made. The state's own police procedures expert, Jeffrey Noble, testified that the analysis should focus on circumstances at the moment Officer Perez made the decision to use deadly force. This evaluation does not require or even allow consideration of how the threat arose or what other means might have existed to combat that threat. And you've explicitly recognized this through the 2 jury instructions that you proposed on these issues.
Let me just clarify for the record. They were modifications to defense's proposed jury instructions that I saw as 4 different instructions, which you presented as 1 and 4.
And I certainly take that clarification, and I didn't mean to suggest that it was going to be given, only that in the way that they were framed and the concerns that were exhibited, I believe that it made clear where the focus should be. And as the court has stressed also throughout these proceedings, the question is not whether the use of deadly force was reasonable, but only whether it was reasonable to believe that a threat of death or great bodily harm existed at the time force was used. Now, even if evidence on these other issues is arguably relevant to Defendant Sandy's position or to other charges against Defendant Sandy, that evidence does not come into play with respect to Officer Perez. Even the state has raised the possibility of 2 different sets of jury instructions for each defendant so that the jury doesn't consider evidence that is not relevant to evaluating the objective reasonableness of Officer Perez's assessment of the threat. Now that all the evidence has come in this case, substantial evidence simply does not exist to enable a rational jury to find beyond a reasonable doubt that Officer Perez could not have reasonably perceived a threat of death or great bodily harm to Officer Weimerskirch under the circumstances. You've heard the undisputed testimony, as Mr. Bergman referred to, including from the lead case agent and the state's own police procedures expert, that Mr. Boyd displayed no objective manifestations of surrendering, regardless of what his subjective intent might have been. You've also heard from the very people who trained him undisputed testimony regarding how Officer Perez was trained, regarding the level of threat posed by someone in Mr. Boyd's position, as well as the objective cues that Officer Perez was taught to watch out for, to perceive intent, means, and opportunity, and to evaluate that. That testimony has been unrebutted about how he was trained to view these things. You've similarly heard undisputed testimony that in this situation, Officer Perez acted precisely as he was trained through the state's own training to act. In short, once all of the evidence that is legally relevant, at least to Officer Perez, has been pared away, all the irrelevant evidence has been pared away, and the focus is explicitly on the elements that must be shown, it's clear as a matter of law that the state has failed to come forward with substantial evidence to enable a rational jury to find beyond a reasonable doubt that Officer Perez shot at Mr. Boyd for any reason other than an objectively reasonable belief that Mr. Boyd posed a threat of death or great bodily harm to a fellow officer. As such, it has failed to meet its burden on one essential element of its case, and Officer Perez therefore respectfully requests and moves the court to dismiss the sole remaining charge against him at this time.
Your Honor, let me start with Officer Perez. I think the evidence actually came in through the cross of Officer Perez himself, who said, if in fact the jury believes that I saw him turn around and his back was to me when I fired, that was not imminent harm and I should not have shot. That came from his own testimony. And there are problems for both these officers on both ends of this. Both the go signal that allows them to shoot somebody and then the stop signal about when they should stop shooting, when the person stops being an imminent threat. This is all in their own training. It's in the reactive control model, which talks about the go signal. You cannot shoot somebody if they're threatening and have a weapon unless they attack you, and that's what they use, and they close distance on you, not you close distance on them. You can't shoot until that happens, and that's where the whole discussion with Jeff Noble came about if he made steps to come at them, then they would be justified in shooting, because it's not just anticipatory shooting. It's not what Defendant Perez testified about. I had a feeling that he was going to lunge or attack, but he didn't lunge or attack. It did not happen. You can't shoot based on a feeling. You have to actually see some manifestation of movement towards you to be able to shoot. And that's what the tool drill is all about. As soon as somebody starts towards you, then you can go ahead and shoot. And so neither one of these officers had that. And it's not whether or not he takes a step on the videotape, Judge. It's their perception, whether they have seen movement that makes them understand there's an attack that's going to take place. And both officers said they did not see movement towards them. I think both said we couldn't see his feet, we didn't see movement. And in fact, in the statement that was given 2 days later, Defendant Perez said, he never said he took a step, never said he lunged, never said he moved towards him at all. That was never in his statement, and the same is true of Defendant Sandy. They didn't see any manifestation of attack or even movement towards them. And so they never had a go signal, and they should never have fired. And in fact, the truth is, even Defendant Perez's feeling that he was going to attack was in fact wrong. He didn't attack. When he was told to get on the ground, after he realized that he was not going to get to walk down the hill, he turned to get on the ground. And Defendant Sandy has admitted that he saw him turn before he shot. He saw him turn to the left. Defendant Perez has said, if the jury believes that I saw him turn and that his back was to me at the time, then that was not a good shooting. That's the stop signal. So they didn't have a signal to go, and they also had signals from Mr. Boyd that he was no longer an imminent threat when he was following their orders to get on the ground. And we've ordered Jeff Noble's transcript, but don't have it yet. My recollection of Jeff Noble's testimony was not that he said he never surrendered. He said he never said he was surrendering, is what he said. He never said, I'm surrendering, is I think what Jeff Noble's testimony is, but I can't, we're getting the transcript. That's my recollection of what he testified about. The other problem for justifiable homicide judges, they first have the burden of showing that one of the elements for justifiable homicide exists. And the only one of the 4 elements from the jury instruction is that they were overcoming actual resistance of James Boyd to the discharge of a legal duty to arrest him. So, through Defendant Perez Cross, he can't be resisting unless he knows he's under arrest. How can he even be resisting? And all of them have admitted they never told Mr. Boyd he was under arrest. In fact, the opposite. They told him he could come down the hill and he would be safe. And so Mr. Boyd starts down the hill, and the first time that he could possibly know that he's under arrest, I don't think it's the flashbang, because that's supposed to stun you. It's when they start yelling, get on the ground, get on the ground, get on the ground, okay? And the first time that Defendant Perez says, get on the ground, is when the flashbang is going off, when he's still stunned by the flashbang. And then the next time he says it is when the dog is running, thank you very much, is running towards him, is the next time he says, get on the ground, when he's defending himself from the dog, and he's not going to lay on the ground when the dog is attacking him. And then they say it 2 more times, and there's a time of about 2 or 3 seconds where you can see it dawning on Mr. Boyd's face that he's not going to walk down the hill, and they're trying to arrest him. And when it dawns on him, he does not go, and that's after he's pulled out his knives in response to the dog, not in response, not because he's resisting arrest, but when it dawns on him that he's under arrest, He doesn't resist, he turns, and our evidence is that he was obeying their orders to lay on the ground. That's our evidence that you have to accept. If I can just take a minute, Judge. I've been handed a case, Benavides versus Shutiva, 215, and New Mexico Court of Appeals, 065, which talks about what is resisting arrest, and they have to know, in order to have a resisting arrest charge under that case, it says that the defendant has to know that the officer was attempting to apprehend or arrest him. That's what the case law says. And again, they never told him that. And should he have figured it out? I think the first chance he had to figure it out is when they said, get on the ground and you're not going to be allowed to walk down the hill. And so when he realized it, he did not resist, in fact. And so they can't even make the element of justifiable homicide. I think we have evidence to overcome justifiable homicide just on that particular element alone. Whether a reasonable person in the same circumstances as the defendant would have thought he was a threat, that's where all of this comes in. Under what circumstances could 19 officers with guns not successfully take down one guy with 2 knives? Was it reasonable to be afraid of death or great bodily harm when you had all these resources and all these people around you? That's a question for the jury. And was it reasonable for them to close distance on him? And again, this is not Defendant Perez, but Defendant Sandy. Was it reasonable for him and Officer Weimerskirch, when he saw him draw knives from 20 or 25 feet away, rather than them backing off, to run forward towards him, creating the danger? I mean, all of that goes to the totality of the circumstances under Mantelli and the reasonableness of their behavior, and that is for the jury to decide. We welcome the burden. We think we have met the burden, both that they were not acting reasonably in defense of another, and that there really isn't justifiable homicide because he never even knew he was under arrest. And when he realized it, he didn't resist. He went to get on the ground. So we would ask the court to deny both motions to dismiss the second-degree murder charges and the aggravated battery charge on behalf of Defendant Sandy.
Your Honor, I actually did order Mr. Noble's transcript. And let me just give you what is transcript, page 32 of my cross, Your Honor. Here's the question. So I actually had you down where you said that Mr. Boyd never surrendered. That was line 19. Line 21. Answer, no, he never surrendered. 22, so that's a correct statement right there. Boyd never surrendered. Answer, as I stand, Boyd, it says Boyd, I stand, Boyd, the statement I just made. Your Honor, they do not have a single witness that they can point to that ever said Mr. Boyd surrendered. They don't have a piece of evidence. They have argument. They have, how many times did you have to sustain objection that he was lying down on the ground? You have to lie down on the ground. Because it's not factual. I don't know what case they listened to. They said Keith Sandy, she just said Keith Sandy never testified that he was moving towards him. That's exactly what he said. He said he saw Mr. Boyd take a movement forward from him. But he didn't see the step because he was focused on the upper body and the hands. Your Honor, he says he was never, this whole issue about arrest is, and you do a lot of criminal, obviously you're a criminal law judge, Your Honor. You understand the fact that they don't say that you're under arrest necessarily, those words, before they place someone under arrest. But we do know, just for what it's worth to rebut that statement, as Mr. Sandy testified to, he was told, I'm not going to put your hands on your head. And he goes, no, I'm not going to do that. That's what happens when you arrest people, and I'm not getting arrested. That's what Mr. Boyd told them. So the idea that he didn't know that they were attempting to try and effectuate arrest is silly. But he doesn't even have to. Your Honor, I guess what I'm hearing from them, and this is what makes this case so bizarre to me, is that if Keith Sandy had shot a half a second earlier, that they're arguing it would have been justified, but this stop go stuff should take place within a quarter of a second, a half second, and it's troubling, but even more so, you could never get a jury to believe beyond a reasonable doubt. They've never proven that it wasn't justifiable because it was a half-second late shoot, according to them, which we don't suggest that it is, but even taking their evidence in the light most favorable to them, that once he started the turn, he shouldn't have shot, even though Detective Sandy described what he was perceiving. Think about that. They're saying that, well, if he had just shot when he was facing him completely like that, if he was a half-second earlier, that would have made it justifiable. That can't be the standard we're holding our officers to. Of course it's not. But what we do have to do is hold the state to the law, Your Honor. And I can't even begin to fathom in a situation when they don't have a single witness saying that Mr. Boyd was ever even trying to surrender, that they could convince a rational juror beyond a reasonable doubt that he was surrendering. Because if he wasn't surrendering, it was justifiable homicide, Your Honor. Thank you.
With respect to the claim that the element number 3 of justifiable homicide by a police officer, the resisting arrest part, as you know, if there's any evidence to suggest that a defense of this type is warranted, then it must be given to the jury. And certainly there's sufficient evidence to allow officers to conclude that he was resisting arrest at the time. So therefore, I don't think there's really any question that if the case does go to the jury, it should go with that instruction in mind. Now, I don't, with respect to the stop and go signals that we're talking about, that's once again argument. I don't know that we've had testimony about what a go signal is or a stop signal, and therefore that shouldn't play into the evaluation. But even if it does, as we discussed before, Robert Johnston testified that these officers are trained that drawing knives is an attack without anything further. Just the act of drawing knives is an attack within this proximity. That is a go signal. Imagine, if you will, that instead of it being a knife that was drawn with this very close proximity, it was a gun that Mr. Boyd pulled out of his waistband. Is there really a suggestion that pulling a gun out of a waistband is not creating a threat that will enable somebody to use deadly force, that you have to wait until it's actually pointed at you before that force can be taken? Of course not. We know that by pulling it out, you now have demonstrated the intent, means, and opportunity to inflict that death or great bodily harm, even without a further manifestation of it. The same is true for a knife in that proximity. So that is a go signal, and that is what they were trained to do. And finally, I want to clear up what I think is a mischaracterization of Officer Perez's testimony. I believe I heard the state suggest that Officer Perez said that if the back was to him at the time that he shot, that is something that he shouldn't, that is a shot he should not have taken. I believe the actual testimony was, the state asked him, if you had seen the back to you at the time you shot, is that a shot you should take? That is a distinction, and really the question is, was the back to him at the time he made the decision to shoot, not at the time the bullet struck him? So once again, that's a mischaracterization of the testimony. Those are, I don't want to belabor the points that have already been discussed. Thank you.
understanding that the court has to view the evidence in the light most favorable to the state, and finding that there's enough evidence to go to the jury. So both motions for directed verdict are denied. It's 5-5. I'm happy to stay and discuss jury instructions, but I can't really keep the staff here beyond 5. So we probably just need to end for this evening and pick up tomorrow at 8:30. I can start as early as 8:15 to give the reporter a chance to set up, so if you can be here at 8:15, that'll give us a little bit more time. All right, so let's start at 8:15 then, and we'll be in recess.